In 1933, a lawyer walked into New York Customs, handed over a package, and demanded it be seized because the novel inside was a federal crime to own. His client, the publisher, wanted exactly that. He wanted a trial. This is the true story of 6 real trials that decided which books America was allowed to read. Real judges, real rulings, real dates, not internet rumors, court records. Here's the mechanism. Starting in 1873, a federal law called the Comstock Act let customs agents and postal inspectors seize anything they judged obscene before it ever reached a reader. For the next 100 years, that one word, obscene, is what put books on trial. The package that lawyer handed to customs was James Joyce's Ulysses. It had already been effectively banned in the U.S. since 1921, after a magazine that serialized part of it was convicted of publishing obscenity under the Comstock Act. Joyce's publisher, Random House, wanted the ban lifted, so they arranged for a copy to be intercepted at customs on purpose, to force a court to finally rule on the book itself. On December 6, 1933, Federal Judge John M. Woolsey ruled in United States versus one book called Ulysses that the novel was not obscene, famously writing that its effect on most readers was emetic, not an aphrodisiac. The Second Circuit Court of Appeals upheld his ruling in 1934. Ulysses was legal in America for the first time in over a decade. In 1957, an undercover officer bought a copy of Allen Ginsberg's poem Howl at San Francisco's City Lights bookstore, and police arrested its publisher, Lawrence Ferlinghetti, charged with publishing obscene material. The ACLU stepped in to defend him. Municipal Judge Clayton Horn didn't just rule on whether the language was vulgar. He ruled on whether the poem had value despite it, finding it had redeeming social importance. That phrase became the legal standard the next generation of banned book cases had to answer. Ferlinghetti's acquittal made Howl impossible to ban again. City Lights kept selling it, and the ruling became the reason serious literature could use language courts used to reject outright. 2 years later, the U.S. Post Office refused to mail the unexpurgated Lady Chatterley's Lover, calling it obscene. Grove Press sued the postmaster directly. In 1959, Federal Judge Frederick Van Pelt Bryan ruled in Grove Press versus Christenberry that the novel could be mailed uncensored. Because a serious literary work couldn't be banned just for containing sex, the court found honest rather than exploitative. The ruling didn't just free one novel. Within a few years, it opened the door for Tropic of Cancer, Fanny Hill, and dozens of other books that had been kept out of American bookstores for decades. By 1966, the question reached the Supreme Court itself. In a book named John Cleland's Memoirs of a Woman of Pleasure versus Attorney General of Massachusetts, the book better known as Fanny Hill, a plurality of the court, led by Justice Brennan, held that nothing could be banned as obscene unless it was, in the justice's own words, utterly without redeeming social value. That single phrase is still the legal backbone of every First Amendment book case that came after it. It was the last major literary obscenity case the Supreme Court fully decided under that framework. The standard it set stood until the rules changed in 1973. In 1972, the school board in Strongsville, Ohio, pulled 2 books off the shelves of the high school library: Joseph Heller's Catch-22 and Kurt Vonnegut's Cat's Cradle. It went further than removal. Teachers were barred from assigning either book or Vonnegut's God Bless You, Mr. Rosewater in class at all. 5 students and their parents sued, backed by the ACLU. A federal district court sided with the board. The students appealed. In 1976, the Sixth Circuit Court of Appeals reversed and split the ruling in 2. On the classroom ban, the board won. A school isn't constitutionally required to teach any particular book. But on the library, the students won. A library is a storehouse of knowledge, the court wrote. Here we are concerned with the right of students to receive information which they and their teachers desire them to have. Catch-22 and Cat's Cradle went back on the shelf. It was one of the first federal appeals court rulings to treat a school library as its own First Amendment space, separate from the classroom, a distinction no other circuit had made before, and one the Supreme Court hadn't yet weighed in on. Minarcini decided the question for one federal circuit, Ohio, Michigan, Kentucky, Tennessee. It didn't decide it for the whole country. That same year, a different school board in a different state pulled its own set of books. And that fight wouldn't stop at an appeals court. It was headed for the Supreme Court. In 1976, the Island Trees School Board on Long Island pulled 9 books from junior high and high school libraries, including Kurt Vonnegut's Slaughterhouse-Five, calling them, in their own words, anti-American anti-Christian, anti-Semitic, and just plain filthy. A group of students sued the board. The case reached the Supreme Court as Island Trees Union Free School District versus Pico. In 1982, a divided court, 5 votes to 4, refused to give school boards unrestricted power to strip books from library shelves and sent the case to trial. Justice Brennan, writing for 4 justices, drew the line at motive. Removing a book for being educationally unsuitable is different from removing it to deny students access to an idea. The case was sent back for trial on exactly that question: why the board really pulled those books. It settled before a verdict. The books went back on the shelves. Here's the part the mystery bait version of this video skips. None of that legal machinery, the trials, the rulings, the paper trail, is how most books get banned today. We are not going to give you a nationwide ban count on this channel. The organizations that track it don't agree with each other on methodology, and the number changes weekly. So putting a figure on screen would be a guess wearing a citation. What we can tell you for certain, because it's a matter of public process, not disputed statistics. The overwhelming majority of today's removals are decided by a single school board vote, not a judge's ruling that becomes part of the public record the way Woolsey's or Brennan's did. That difference is the whole point of this video. A trial produces a ruling, a document anyone can read that has to give a reason. A board vote doesn't have to explain itself the same way. Ulysses, Howl, Lady Chatterley, Fanny Hill, Catch-22, and Cat's Cradle, and the 9 books in Island Trees all got a day in court. Most books challenged in America right now never do. And one more thing the paper trail shows. Every book in this video is still in print. Ulysses now tops lists of the greatest novels of the 20th century. Howl is taught in the same universities that once debated whether it was safe to sell. Lady Chatterley's Lover became a national bestseller the year the ruling freed it. Catch-22 gave the English language its own phrase for an impossible rule. And the books the Island Trees board called just plain filthy are back on the shelves, where they've stayed for more than 40 years. The bans are footnotes. The books became canon. 6 cases, 6 turning points. 1933, Ulysses rules obscenity has to mean something more than shocking. 1957, Howl asks whether art gets weighed against its offense. 1959, Lady Chatterley's Lover moves the line again. 1966, Fanny Hill sets the Supreme Court standard. 1976, Minarcini takes the fight into a school library for the first time. 1982, Island Trees versus Pico takes that same question all the way to the Supreme Court. Free printable bookmarks for every book in this video. Get them at hookedtobooks.tv/bookmarks. If you wanted the actual paper trail instead of another "they don't want you to know" video, subscribe. We're doing the real research on this format going forward.